Hey everybody, welcome back to the weekly immigration news recap. I'm really happy to be joined today by James Hollis for our first episode, our first recap of the new year. Today is January 8th. It's about just before 1 p.m. Eastern Standard Time, and this episode will be released tomorrow. James, you were here 6 months ago. We still do the time stamping, and I'm glad that I do that because it's come in handy a couple times when breaking news comes out a couple hours after we record this and we don't cover it in the podcast. So if that happens again, we'll cover it next week.
I can't imagine them doing something on a Friday and changing policy significantly.
Yeah, if I at some point I might be forced into recording these on Saturdays, but I probably wouldn't be able to get guests because that's the one time where immigration attorneys like you hopefully take a little time to yourselves. So,
Yeah, exactly.
but
You have kids running around in the background.
yeah, exactly. But James, for those who didn't listen to our episode 6 months ago and are maybe newer to the podcast, can you just tell folks a little bit about you, your practice, and the types of cases that you do at McEntee Law Group?
Sure thing. Yeah. So I am at least nominally the head of sports, entertainment, and business immigration at the McEntee Law Group. My practice is a lot of O's and P's and EB1s. I also do like standard corporate immigration stuff. In addition to that, I I didn't want to use the word wizard. I do a lot of consular related visa stuff, resolving complex consular issues, annoying consulates, expediting cases. I also run a company called Fact Pattern and a product called Consular Intelligence and a newsletter called Consular Update, in which I basically keep my ear to the ground and try to figure out what's going on, see what's going on in my cases. Talk to a lot of other lawyers. Ironically, I feel like Consular Intelligence has actually just has become me because I am the intelligence because I'm just talking to other lawyers all the time and getting the information. So it has been a fun journey from that perspective. But a lot of business immigration stuff, a lot of sports stuff, a lot of circus performers, some pro wrestlers, uh, some dancers, all that sort of thing.
Yeah. Well, I'm a big fan of the Consular Update newsletter. As I've said many times, we've referenced it on this podcast. Even when you aren't here, James,
Really? I need to
just to
listen
show
better.
just to show that we're not being performative and kowtowing to whoever our guest is that month or that week. No, James, I think it's incredible the number of different areas that you have sort of your hands in the immigration space. You're one of the few immigration lawyers who 2025 rolled around and you said, you know what, I think I'm going to do more things. And and here you are doing everything.
It's a diverse experience that I come with it.
Yeah, here you are doing all the many things you just listed, but that's what makes you a great guest to help me recap the news of the last couple of weeks over the holidays. Because as all immigration practitioners who might be listening know, it didn't slow down one bit, and so we have quite a bit to cover today. We're not going to get to all of it, and we're going to do things a little bit differently than sort of the normal format. If you're a returning listener, James and I are just going to go sort of back and forth on what we thought and talk about what we think are some of the biggest, most impactful immigration trends or news stories that has happened over the past couple of weeks, and a little bit before that, because many of these trends and developments are just snowballing and ongoing, and some are getting better and some are getting worse and some are staying the same, and there's a pin to drop somewhere down the line, and we're going to talk about all of that. So that's how we'll do it for the next 30 or 35 minutes or so. James, to kick things off, it might be a good segue to just go back to your consular update and your consular intelligence, headspace, and talk about some of the things that were happening in December at the consulates that I think all immigration practitioners, attorneys, skilled mobility professionals, and individual foreign nationals were dealing with in sort of the weeks leading up to Christmas.
Sure. Yeah. I mean, the biggest thing I feel like is social media vetting for expanding to H-1Bs and H-4s. As we found out, social media is incredibly important to the United States, and what people are saying in their own languages on social media uh, is critical to the decisions that are being made by the consulates. I'm being sarcastic here because, quite frankly, I think they've been doing social media type vetting for a really long time. This was announced right in the middle of December, and I think it was timed to be a real pain in the ass for applicants who were going home for the holidays. We've seen it particularly in India, which we'll talk about in a little bit. But the general outline of it is social media vetting, like the social media vetting that we saw for the student visas, is now happening in the H-1B context. I had an email this morning from one of my H-1B beneficiaries in one of the Asian consulates, not in India, that asked me, hey, everything went well, but I got a 221G notice, indicating that they needed to review my social media. Is that normal? And I was like, well, yeah, it's normal now. It wasn't normal when you scheduled the appointment. But I would say one of the distinctions that we've seen in the H-1B context that's different than what we saw in the student visa context is that it looks to me like most of the consulates are actually following the guidance that came out of that original presidential proclamation, where it was like, you will 221G the person, you will review the information, then you will reopen it and approve it if that's going to happen. So we actually are seeing those 221G administrative processing notices. I also saw it in a student visa case in December in I think it was in Mexico, where they actually did the 221G as well. So maybe that's becoming a little bit more uniform, but it certainly wasn't uniform back in the spring and summer. Part of that is also probably because they didn't have the same time period that they have created for themselves now. So in addition to that, of course, we've seen H-1B visa interviews delayed throughout India and in some other countries as well. I think we saw some in like Vietnam as well. But the situation in India is just try not to curse, a mess. It's we essentially saw them move hundreds of visa applications from the Christmas period to April, May, June, July, August, without any notice. A lot of the people were caught out by that, obviously, because they traveled to India to go and do the VAC appointment. So India, for those who don't know, India has two different types of appointments. So the first one is a biometrics appointment. So this is what they do at a lot of the big posts, is basically they bifurcate the appointment. So you do the biometrics and then you just do the visa appointment after that. So a lot of people were there, scheduled the biometrics. They didn't move the biometrics appointment, so the people still have to go to the biometrics appointments, but then they moved the visa appointment for months and months and months away. And in terms of rescheduling availability, it just really isn't there. Maybe it opens back up, and that's sort of like the one spot of hope that I have, is that maybe, over the course of the next couple of months, they open up some more spots because they realize that demand has probably fallen off a cliff, because everybody who's in the U.S. is like, I do not trust you. I'm not going abroad to prosecute my visa. But unfortunately, what that does always result in, which I think the government doesn't really give a lot of credence to, is you get these humanitarian issues where somebody went to see a dying family member and they had to process their visa while they were there, and now they're stuck. Or like somebody wants to go see a dying family member and they can't do that because they can't get back for 6 months and they're going to lose their job. That's the type of situation that I feel like they really just don't care about, or they are really trying to harm people. And again, I generally don't think it's the people on the consular level that are directly trying to harm people, but I do think the folks in the administration, like, this is what they wanted to do. This is why they announced it when they did. Like, they could have announced it in the fall and dealt with it that way, but instead they announced it immediately, like, throw everybody's plans into disruption. It's policy by chaos, and it's intentional. And it's a terrible, terrible way to run, legal policy, because you're essentially penalizing people that have otherwise followed the exact process that you would follow. So it's like arresting people at the courthouse when they've actually appeared and are abiding by the legal process. Like, what's the point? Like, why don't you arrest the people that don't follow the process instead of harming people that are trying to do the right thing?
Yeah, the administration has a clear track record, and I don't think they would, think that this is an insult, because it's what they intend to do. But of announcing very significant policy changes that are effective immediately, and effective immediately doesn't allow businesses to plan, it doesn't allow individuals to plan, and it creates a lot of chaos. And when that chaos happens, everyone comes to you and asks for your help. No, you or other immigration attorneys, but no, I mean, I'm curious to hear some of the most extreme examples that you heard on the India case, because I talked to a few foreign nationals. One is an employee of one of the big Silicon Valley tech companies that we all use their phones, and she had a trip planned back to India, needed to renew her visa, had her appointment scheduled for January of 2026. It got rescheduled to March of 2027.
Oh,
And,
God. That's the last. That might be the latest I've heard. I had heard January 2027, but it's just like Like, why don't you just
Yeah.
cancel at this point?
She was lucky. She was able to not go right at that point. And hopefully there's a way where, like, like you mentioned, she can find another appointment that's earlier so she can. But what I'm curious about too is because this is something you have your finger on the pulse of. Like, my suspicion is that travel for foreign nationals who are on H-1Bs or other, temporary visas or in the green card process, whatever it is, back to their home countries, I'm sure has decreased substantially in 2025, just out of fear of everything.
Well, and
But
I know a lot of the companies are specifically advising that as well. Like,
yeah,
if especially on H-1Bs, like I'm advising clients on O visas as well. Like, I don't trust the adjudications that we're seeing from a lot of these posts.
no,
So it's much safer to stay here than it is to sort of risk a 214B refusal. But it's the same deal with H-1Bs, except, the good thing about O1 and P1 visas or whatever is that they're less targeted because there are fewer of them.
right.
But it just seems like it's in the crosshairs at the moment, and you can't trust them one way or the other. Like, again, you have people that were told the day before their appointments that they are rescheduled for 6 months later. It's
Yeah.
you can't trust anything. Like, you scheduled, you paid your fee, and now you're in a real situation.
Yeah, and companies at this point, from the folks I've been talking to on the insider, just like a lot of them are just left to fully contingency plan where they have to accept that they're not going to get their employee who's hired at a office in the U.S. back at that office in the U.S. and they're going to need to be rehired by the foreign subsidiary overseas in their home country if they have one. They're obviously big enough companies that that's not too much of a nuisance from the company's perspective, but it certainly is from the individual's life's perspective because they have mortgages back here or rents back here or a car or kids in school or all of the many examples.
This is the thing that always bugs me about significant visa changes like this is, I feel like folks who are in the United States and have property here or have, like, you know connections here, at some point we have to guarantee the rights in of those people in their property in the United States. Like,
Sure.
if somebody can't get back here to sell their house or sell their car or, like, do anything, it's essentially the government stealing all that stuff from them and not allowing them to come back. And it's even worse when, I had a client who went over there with a very young U.S. citizen child, and all of a sudden it was like, hey, sorry, U.S. citizen child stuck with U.S. citizen parents and or sorry, stuck with Indian national parents in India
Yeah.
for 6 months, and it was like, guys, it's a U.S. citizen, medical care, like their doctor, vaccinations, like all of the things that are needed for a young child. Now this has been thrown into an entirely different country, an entirely different culture, entirely different germs, all of these different things. It's a real, significant problem. I don't even. It just seems very cruel and incredibly stupid because what are they finding on the social media vetting? Like, my guess is very little. Most of the people who I talk to all the time are extremely conservative about what they would post on social media because of the backlash that we've seen over the last, like, year.
Mm. Yeah,
Which is
absolutely.
why my social media is the exact opposite of that.
Yeah, yeah. Well, luckily at the moment, at least, you don't have to worry about going for a visa interview in Seoul or Chennai. So
No, exactly.
you never know, though. You never know in the future. Um, okay, so I want to pivot to some more some other big news items that happened here in the U.S. But before we do that, I think just kind of want to keep pulling on the consular thread because, again, the social media vetting, the ramifications of that, the appointment cancellations and reschedule, like that was every immigration attorney I talked to in the middle of December before the holidays. Like, that was the number one thing that they were dealing with. What else has been going on that maybe hasn't been as covered or as hasn't had as much attention paid to it by the practitioner community specifically because there's so much other noise at
Sure.
consulates overseas, and then maybe this sort of springboards it into, like, more forward looking, like, what are you watching out for on the next 3 months now that we're in 2026 in terms of consular behavior.
Yeah, I would say it's the shifting sort of treatment of police uh, interactions by visa applicants.
Right.
I would say right because one of the things that happened right as they announced the new social media vetting is like we saw in the F1 visa case or the F1 visa revocations and CVIS terminations back in like March and April of last year. We essentially saw a lot of revocations start happening, and visa revocations are something that happened. Sort of not directly at the consular level. It happens at the consular level, but it is initially identified by an office in the United States. The office in the United States then tells the folks at the consulate, hey, you issued this visa, you need to revoke it because this person was arrested or got a DUI or like whatever it is. So that's something that started to ramp up, and it's again, it's something that's happened. It happens consistently over the years. Like if somebody gets a DUI and they're here on a non-immigrant visa, our expectation is that the visa is going to get revoked in the United States.
Yeah.
Um, uh, some of the battles that have occurred between lawyers and the government over the past like 9 months has been, with that revocation, can the person be removed from the United States, very quickly? And that was essentially the battle that happened with the F1 visa revocation. Is that when they terminated the folks' CVIS records, the goal was let's leave them without status so we can remove them. But they didn't go through the correct process they were supposed to go through. But anyway, so as that was all happening, we also saw a concomitant, a process happening at a lot of consulates abroad that was essentially if you have had police interactions, regardless of the outcome of those police interactions, regardless of whether you were convicted of an offense, we're going to deny your visa under INA Section 214B. And it's a weird thing to understand. INA Section 214B. I know I did an entire newsletter on it where it was like it is the sort of threshold requirement for getting a non-immigrant, most non-immigrant visas to the United States. The ones that are excluded from that are like H's and L's, and then one other visa that I can't remember because I don't think I've ever done it. So, essentially what they say when they're denying under 214B is like, we think that you're going to come to the United States and continue to commit crimes or whatever, and
Yeah.
because of that, you're not eligible for this visa. So stop being a person who's going to commit crimes in the future. Precog or like Minority Report stuff. It's like we think based on the thing that we know about you that you're going to do this again in the future. So because of the suspicion, we're going to deny this visa and not really look into it.
Yeah.
So what we saw from a variety of consulates, and most particularly it was U.S. Embassy in London, which is normally a pretty good place to process visas, is essentially anybody who had a police interaction for a period of time was getting denied. And it could be anything from like an arrest with no conviction, no like the government in the UK was like, we don't have any evidence of this, we're going to drop these charges.
Mm.
Visa denied. We don't care. You've talked to police. You've been arrested. That's enough for us. And it was very significant. And this came around the same time that we saw the requirement that you have to only process in your country of nationality or residence. So everyone was basically being locked into their single consulate or their multiple consulates in a particular country. So the good news about that, there doesn't seem like there was a specific, guideline sent by the State Department to say, hey, you got to deny everybody who has a police interaction. And what we've seen is that it's loosening a little bit, and particularly in the UK, because I was telling people basically don't apply for visas if you have a police interaction. Fortunately, that seems to have resolved itself a bit. Some leadership has changed that I'm aware of, and I think it's only a good thing. They simply for a while they were not analyzing the situation because they were so concerned about what was coming out of the administration. It's like okay, well you're telling us that traffic offenses in the F1 visa context are what you want us to revoke visas over. That means we need to take minor things like that seriously for the other visas that we're adjudicating as well. And I think that was the message that sort of got sent to a lot of the consulates. So you saw that inconsistency, but hopefully that's shifting a little bit.
Yeah. As you're saying all this, and again, like as a reader of your newsletter, knowing that you have plenty of content to cover every single week when you write the newsletter.
Sometimes
Um,
too much. God.
yeah, right. I feel the same thing. I'm just thinking as for the immigration practitioners, attorneys, or global mobility folks who listen to the podcast, like I know they're all struggling to stay on top of like, okay, there's this new change or this new trend. either official or unofficial, or I read about it in Consular Update or Consular Intelligence. Um, how do I like implement this into my how I advise my clients or my programs when it comes to that fact, right? Like, let's say someone had a night, in uh, on January 8th, 2025, right? A law firm or a global mobility team had a nice, FAQ for travel advisories for all their foreign nationals that they sent out. What does that look like now for as someone who's covered all of the developments over the last year? Like, like seriously, how many more bullet points or how much longer might like a travel advisory or FAQ for employees or for clients look now than it did a year ago?
God. I mean, I feel like at some point we have to just simplify, because it would be one thing sort of tracing and tracking all the things that are happening.
Yeah,
I sort of I've talked to a lot of other immigration attorneys about this as well, because there's this sort of there's an urge to like follow all these things, but there's also I feel like there's a better way to deal with it, and it's like, hey, don't defer travel unless it's like essential, unless it's an emergency, unless it's like a very significant issue,
yeah.
because everything's just so inconsistent in the moment at the moment. And I mean, I think to some degree it depends on the type of visa that the person has. Like again, H-1Bs are particularly in the crosshairs, but you know it makes me want to recommend that people don't travel, which is not something that I typically do. And the folks who my clients, and when I talk to other practitioners, know like I'm not a particularly conservative immigration lawyer in terms of like being afraid of things that are changing. But the current environment, it's just I don't know. It's just not it's not a good time, and I feel bad for the global mobility folks because they're dealing with this on sort of a broader basis. But it hitting the red button and saying stop is probably the best thing to do at the moment, because particularly for you know the targeted nationalities, because if they're not in the U.S., it becomes very difficult to navigate around some of these issues. And I mean, I guess we haven't even talked about the nationality related processing, but I
I
guess
was
we'll get to it.
No, that's perfect. I was going to bring that up next to sort of our last, consular topic here before we move on to some other things. But yeah, like obviously the entry ban has been expanded. That was one of the developments, and there's more countries. Was it 38, 39 countries now that are part of the
39,
full
yeah.
or partial entry ban? And then there's a lot of other components that come with that. And tied to that is the visa bond pilot being expanded as well. So look, I looked at I'm sure you know them too. I looked at these numbers like 6 months ago. The countries that are included on the travel and entry ban list, like overall, don't make up a massive percentage of the number of immigrants who are coming here on an annual basis. It's still tens of thousands, if not low hundreds of
Makes up a
thousands
large
now.
percentage of the people that come over here that Donald Trump does not like. But
Yeah,
that's
well, it's
I
that's
wonder what I wonder what the thing he doesn't like about that. Interesting.
what do you so like what are the full ramifications of this? Is it basically, I mean, maybe it's as simple as what you were just saying, like if you're from one of these countries, you're currently in valid status in the US, like you're going nowhere basically
Well,
is
I mean,
or
step one, yeah. Like, I mean, as you said, like, there's not a ton of there aren't a ton of like business visas coming from these countries.
right.
Every once in a while you'll get dual nationals of some of the countries. Um, you know, uh, that the bigger trouble is one, you know, uh, family-based immigration, which is obviously what Trump has been wanting to target for years based on his
Yeah.
like prior things about like chain migration and all of that. The bigger problem at the moment is that USCIS seems to have taken this as a recommendation to not process any of the visas for any of these 39 countries. And the
Yeah.
stuff that we're seeing out of USCIS related to that, like basically put the people in the United States from these countries in a lot of trouble. We're seeing, and I've seen like the text. Fortunately, I haven't had to deal with this yet, but the text from USCIS saying that they're going to deny changes of status to nationals of these countries because of country-specific factors basically related to the proclamation that's created this visa ban. So basically, we don't like your country, so we're not going to, confirm your change of status, or we don't like your country, we're not going to process your naturalization application. We don't like your country, we're not going to approve your adjustment of status application. We don't like your country, we're going to issue a notice of intent to deny over the asylum application that you filed because of where you're from, which is just
Yeah.
like, it's like standing the law on its head. It's like, oh, well, you're applying for asylum from your country. We are then going to, deny you and presumably send you back to that country because of the country-specific factors, is the reason that we're stopping processing of this. It's just like, it's circular reasoning, and it's extremely like problematic. Like I've got a person who I'm preparing an adjustment of status application for him and his family, who qualifies in a very significant, discretionary category, like an EB2 NIW. As an EB2 NIW, the government's decided, yeah, this person is extremely qualified, very, very talented person. But if I file that adjustment of status, they're
Right.
going to tell me they can't process it because of the country he's from, and it just doesn't make
Right.
any sense to me at all.
Uh,
And they also have a pending asylum application. I don't know.
yeah.
The idea of them sending them back, it would be absolutely insane. They would die. So it's a really tough situation.
Not that there's many left. Not that there's many opportunities for extensions left at this point either. But extending existing EADs as well from folks from these countries is going to be a real problem. Although extending EADs in any category at 2026 feels like it's going to be a
Well, and
real uphill battle.
I will throw out a couple of recommendations. One of them is that I know my friend Jim Hacking, who's based in St. Louis, is leading a big lawsuit against this USCIS processing, again, because it's madness.
Yeah.
So that I know he just added a bunch of plaintiffs to an amended complaint. I think it was earlier, into last week or beginning of this week. So Jim Hacking got a lawsuit in there. He's a great litigator. He's a great person as well. And hopefully that goes well. The impacts litigation. So my previous firm, Siskin Susser, and Cook Baxter in Atlanta, and why? Oh man, why am I blanking on the Denver firm's name? I feel bad. Aaron, Aaron, your firm in Denver. Joseph and Hall.
I'm gonna send this to him.
I got it.
Joseph and Hall.
Joseph and Hall in
Yeah.
Denver, they are also onboarding a case to challenge this as well. So, hopefully one of those succeeds, because
Yeah.
I don't understand how people feed themselves if they have legitimate asylum applications, can't go home, and also can't get their applications approved here. So it's just pushing people into a really tough situation.
Yeah, it certainly is. Speaking of litigation, that's a good segue into the other topic that I wanted to talk about that's more homebound here, and that a lot of people, I don't think missed, but I think, put it away for a little while so they could enjoy the holidays because it came out just 2 days before.
Opened a bottle of wine immediately after, and
Yeah. Exactly. A big I'll deal with this when I get back. But the litigation that the chamber mounted, the U.S. Chamber of Commerce mounted against the Trump administration's executive order to impose a $100,000 fee on new H-1B recipients who are overseas and then come into the U.S. Their company's required to pay a $100,000 fee right now. The infrastructure for it exists. I still don't know if I haven't heard of anyone paying it yet. But it's available. You can pay it if you wanted to. That litigation saw a defeat for the U.S. Chamber of Commerce, which I think surprised a lot of people. I think that it was assumed that there are three major lawsuits against this specific action around the $100,000 H-1B fee. A lot of folks assumed that the chambers would be a pretty heavy hitter and have a good shot in the court that they were in the district court in D.C. that they were in with that judge of getting an injunction for the chamber's members, and then sort of it snowballing from there and sort of ending this fee for employers heading into the H-1B lottery, which this whole sort of saga has a lot of implications for. And I'll talk a little bit more about that in a minute, because as James and I were talking before we started recording, and as many listeners know, like, I'm following what the implications of many different things, including this, are going to be for employers and the lottery that's coming up in like 60 days here was when registration opens. But
Uh-huh.
James, I'm curious to
Is
get
it already
your
that, is it
reaction
already
as
that close?
oh yeah. Yeah, it's very close. I'm curious to get your reaction as somebody who knows the litigation space very, very intimately on sort of what maybe happened here in this particular case.
Dude. Yeah. Um, I feel like we've gotten to the point where INA Section 212F can mean whatever we want it to mean. It's been one of the most litigated area, well, probably the most litigated area other than the Administrative Procedure Act over the course of the last, what year is this? 2026, 6 years at this point. The thing is, it's like a line in the immigration code, and it clearly gives the president a lot of authority within the scope of immigration rules. What's never clear until we have a court decision is exactly what that scope is. Like we previously seen the case, uh, you know, uh, we've seen them prioritize visa processing based on it. We've seen them do visa bans based on it. We've seen them lose in court cases in visa bans related to it. Ultimately, when I read INA Section 212F, I see it as an admission ban. Unfortunately, it seems like Trump might have the ability to create an admission ban like this. But I would also say that Biden administration should be held responsible for this as well, because rather than push back on the interpretation that the Trump administration made during the pandemic on like the expansiveness of 212F. So they were using it for everything. They're using it for, creating a visa ban from Europe, like basically controlling immigration via that pathway, and then, not issuing visas. So basically not allowing people to get around it. So, hey, you're banned from admission, so we're also not going to issue you visas. That was something that we had challenged and by we I mean Impact Litigation challenged and actually won in 2021 or 2022 against the European visa ban. But then, the other battle that had occurred was over the diversity visa lottery, where the prioritization scheme that the State Department had been using was basically like intentionally limiting the number of diversity visa applicants that they were processing. So it was like, hey, we're only going to do 10 diversity visa appointments a year or a month or whatever. So everybody else who has to get it, the process done by the end of the fiscal year are basically screwed in this particular country. And it was their way of sort of pushing down the number of diversity visa immigrants they were getting from a particular country. It was found to be unlawful. Government lost that case. And then the Biden administration came in and appealed it. And it was like, okay, well, now we see how further expansive this can be, and they appealed it and they won, unfortunately, after like a year and a half. But we basically see how expansive 212F can become, and it's basically become a nightmare that's eating immigration law, and it's giving the president unfettered power in a lot of ways. So obviously I'm hopeful that the other lawsuits are in some way are able to push back against this, because otherwise, I don't see what's keeping Trump from just being like 212F, I'm doing whatever I want. And the sort of counter argument to that is like the law says all of these other things that the government has to do. Can the president then go, hey, 212F, no more O1 visas? Like,
Yeah, right.
like that's ultimately like he's able to then individually legislate as much as he would like, and there has to be some evaluation of where the limits are on 212F, and I think that's why litigation is continually important, because there's nothing in the law that actually says what that guideline is.
It's a really smart point, and I'm obviously not as entrenched in the litigation space around immigration as you are, so this might seem like a more naive point, but I imagine it's rings true to a lot of listeners who are more like me and on the outside. But yeah, I mean, like, look, the actual laws that all of this is based off of are 30, 35 years old now. And the more litigation that there is, like you just gave a very specific example of how like this litigation snowball sort of takes place, and one court rules on one thing and then that becomes precedent. And the next thing you know, like, oh, well, this opens up the opportunity for us, the administration, to now try these 9 different things that we couldn't try before, and then you have to go and litigate each one on the same standard. And I mean, I could go on and on. I'm sure everything I'm saying is conversations you've had many a times over some drinks with your fellow litigators. But
Ironically, I feel like the judge. I think I'm right about this, but the judge in that H-1B case is the one that the Republicans are trying to get impeached for one of the other cases. So it's an
the
interesting little.
chamber the chamber thought it was they thought they were picking the most favorable. They're very intentional about where that suit was filed. Yeah, that's why everyone was sort of assuming like that was going to be the one that was fast tracked, and that was going to be the one that was going to end this. I should note before we move off this topic, sort of transition quickly, that Reuters reported 2 days ago that the U.S. Appeals Court did agree to fast track um, this case, and so they'll be taking oral arguments in the appeals court sometime in February. The chamber's basis for arguing the need to fast track the appeals process is that the H-1B lottery is coming up, and that this has major implications for the H-1B lottery, which indeed it does. And James, I know the lottery's like, I know at the moment, like many of you're not maybe representing as many H-1Bs as you did in the past, and so big H-1B programs doing a bunch of registrations in the lottery isn't as much of a concern for your clients, but the space around the H-1B lottery sort of has a lot of tributaries that come off of it, depending on what the market is doing and depending on what the government is doing. And really, the reality, and I laid this out in my newsletter before the holidays, before the announcement came out about the $100,000 fee being challenge being denied. And then before the final text of the weighted lottery rule came out, that like, look, all of these factors are shaping up to create a less competitive lottery for some, and lock other folks out of the lottery entirely. Primarily folks who have level 1 prevailing wages, many of whom are students, regardless of what company you work for. And then also, if you're living abroad and you in the past your company was willing to, or a company was willing to submit you in the H-1B lottery, that's not going to happen anymore, with the fear of the $100,000 fee still, very relevant, very concerning. So James, you can take this in any direction you want. The sort of specific question I wanted to ask you is because I'm already seeing a lot of marketing around, hey, check out the O1 alternative. It's very,
No,
it's very reminiscent of 2 years ago with the NIW, and that's played out a certain way. So I'm curious, like, just for your overall thoughts on this ongoing H-1B saga and sort of what you think it means for the other areas of immigration law that you're obviously very highly active in.
Yeah, well, I mean, the first thing I would say is that I didn't realize that we could have saved ourselves the trouble of responding to all those level 1 RFEs like in 2017, 2018 by just getting rid of all the level 1 jobs and the lottery. I mean, that would have saved me a lot of time and stress,
Yeah,
and
yeah,
also saved USCIS a lot of losses in litigation, because that did not go very well for them. And I guess maybe that's one demonstration of like, hey, look at the different ways that policy can be enacted.
sure,
When you do it in a really lawless way, like USCIS does sometimes, where they're like, hey, we're not going to tell you this. We're going to create policy via RFE. That they get into more trouble that way versus when they create it via regulation and they clearly tell you what's actually happening. They can achieve the same policy ends that they want without being chaotic and screwing people out of like very specific funds that have been paid to the government.
yeah,
But regarding the lottery in general, our firm probably does like 80, or ideally does like 80 to 150 of these a year or whatever. So it's something that we're certainly planning for. The weighted lottery process is going to be interesting, because I mean, on the one hand, like I've watched and we were engaged in litigation even a few years back with related to the sort of way that they were doing the lottery selections. It's going to be really interesting, and first of all, whether the lottery happens under the current regulations that have been put out there, because there is going to be a lawsuit on that. I know Impact Litigation is preparing a lawsuit on that. That is the plan would be to try to stop it from happening this year. We'll see what happens. again, litigation's not been particularly favorable. I always do think it's really petty as well in it when they create a new rule, and this it just shows you the intent of the administration at this point. They do notice and comment, and then they completely ignore all the comments that they receive and do not change the regulatory language at all. Like when you see that in a regulation, the reason you see that in the regulation is because they don't care what the comments are. They're going to make the policy that they want to make. And
You know
it's
what? You know
not,
what's weird is on this one they did, and it made the rule significantly more confusing because I have some folks who have been on the podcast before from the
really.
economic innovation group, and they basically wrote they published it as an article, and then they put it in the public comments, basically arguing like, hey, if the administration's goal is to select the folks who have higher wages, right, who are like higher skilled based off of their wage, doing it by prevailing wage doesn't make any sense, right? Do it by real wages, which I think the administration might want to do, but they have concerns over their chances of winning, a challenge against
What,
in
but
court.
also like they're probably over their ability to code that properly.
Yeah,
You know what I'm
and
saying?
so and so,
It's easy to do
but
wage levels because it's like, oh, it says wage level 4 here. This is how we can make
yeah,
that determination.
right.
Versus like what the total amount is, and yeah, no
It
offense to
it
the people that are coding the lottery system. I have
yes,
full
yeah,
faith
yeah.
that you're going to do a great job, but maybe
Yeah,
not with work
the track record's a little shaky there for sure, but there's no disputing that. But no, in the text when I read the final rule just before Christmas when it came out, Andrew Kraybaum dropped it in his article, the PDF. Uh, it was super confusing because they sort of like in a weird backwards way implied that they were changing the rule to make it so that the highest salary had four entries versus based on prevailing wage level. So it didn't matter like your geography or not. And then you read through the rule, and like you said, it's all the exact same text, right? But they try to do a little bit of an end around to address that comment without actually addressing it, which was frustrating for me, who had to spend an hour figuring out whether or not it
You're like,
did
why?
actually
Wait, why
change
does
or
the
not.
regulatory language look identical? It's like, yeah.
Yeah, exactly. So sorry, I cut you off there. Final thoughts on sort of the H-1B, all these H-1B changes from you.
It's just it's all of the changes that we're seeing sort of across the board in immigration at the moment. It goes back to what you just said about like how old this law is. Like
Yeah,
the reason that they're having to make the changes the way that they're having to make them is because we don't have a modern law. Like I think everybody who has to deal with the H-1B process, lawyers, employees, companies, the government, Congress, that everybody agrees that there are problems in the system because it's an old process, and the process doesn't necessarily reflect the way that business is actually conducted these days. It doesn't reflect the government's desire to sort of change the allocation of the visas either. There's a better way to do that. The way that they're doing it right now is sort of like they're hammering it and saying like, oh well, better wages it means better H-1Bs. And what I think they need to do, and I think this happens for a lot of the immigration law, is we need to define as a country what we actually want and what type of like visas and employees and foreign nationals actually benefit the United States, and that requires a serious discussion and serious negotiations. And you're not going to solve the H-1B problems by requiring a fee to be super high, because ultimately the H-1B problem is that some feel that some types of employees that use the H-1B and some types of companies that use the H-1B are abusing the system and forcing out U.S. workers, which is not the purpose of the H-1B, and it's not when the law was created. The entire purpose of having a labor condition application was that didn't happen. But now we see actions over the course of 30 years or whatever that show how the system can be as it's currently created can be abused by certain actors within the system. I think you got to fix that issue, and I don't think you necessarily fix it by saying, okay, we'll pay everybody more. Like what you're going to do is basically stamp everybody into and push them into like other types of activities, which I think you also see in the regulations where it's like, okay, well, if you are trying to get around this by doing clever things, maybe we're going to come back around and take away the H-1B or something like that. Like
yeah,
people are going to figure out a way around whatever this rule is.
100%.
Because we understand the folks who do H-1Bs all the time understand this better than the folks who are drafting that regulation. And the folks at USCIS probably understand it better as well, who actually adjudicate these applications. Like they're going to see it also. Ultimately, it's something that's going to be in place for a little while. Is it going to fix the problems that we see economically and the problems that we see, generally speaking within the visa system? It's not, because the only thing that's going to eventually change that is when we as a country decide that we need to make a real immigration law that is not 50, 60 years old, and that reflects the fact that we live in an internet society.
Well, James, I could talk to you about 19 more topics here, but that was too good of a point to end on from you for the first podcast of 2026. So we're gonna wrap it up there. James, where can folks find you? Where can they follow you? I'll put links to everything in the show notes, but just tell everyone where they can find you and follow you.
Yeah, biggest place honestly is LinkedIn. I'm posting there all the time. James Hollis on LinkedIn. I used to have a Twitter account. I still do technically, but don't go on there. It's terrible.
Yeah.
You can also find me on McEntee Law Group, and every once in a while you'll see me on some other places. Consular Update. I post links to Consular Update every week. If you want to get that newsletter, you can definitely see that. But yeah, mostly on LinkedIn, and I will talk to people. You can email me too, but God, just fewer emails.
You going to any events in Q1 or Q2 2026 around the country?
Is June in Q2?
Yeah.
I'm speaking at the ALA annual conference in June in San Diego. That's the one that's on my list right now, but I'm sure it'll be something else in and around that as well.
All right, sweet. Well, James, thanks for coming back on. You were the first two-time guest who's an immigration attorney on this news podcast.
Oh, come on, give me my trophy. That's great.
I'll send you I'll send you one of those YouTube plaques. It'll probably be plastic.
Oh man, we didn't even talk about OnlyFans artists. Come on, how do we not do this?
For another time, we'll talk about that next time. For number 3 when you're on. All right, James. Thanks so much. Thanks everyone for listening. We'll see you next week. Bye bye.